Welcome to Notable Approvals. I am attorney Amanda Schaefer. A very unique case to talk about today. Before I get to that, quick reminder, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video helpful or know someone who may, please hit that share button so that other people can find this video as well. So today's case is about a client who is a native and citizen of India. And this has a unique fact pattern and a couple of things I want to point out that we can definitely learn from. So this is a parent of a U.S. citizen. Her and her husband entered the U.S. in April of 2021 using their B2 visitor visas with the intent on visiting their daughter and grandkids. Now, when the client first filed, I was not their attorney. They didn't use an attorney. So some of the details are, I don't like to fudge any details. I like to be very straightforward. I can't remember the exact order of some of the things that happened before I came on board. So I'm going to do my best. But I know I relatively have the fact pattern down. I don't remember if dad was sick before they got to the U.S. or he got really sick when he got here, but very shortly, within a month of arriving into the U.S., dad got very sick. And they were planning to return home, but when dad got sick, I believe they found out it was terminal, that they didn't want to send dad back to India really sick, and they didn't want to send mom back where they didn't have any more family left. So about a month after their entry, all of this happens, and the daughter, who is a U.S. citizen over the age of 21, therefore an immediate relative, decides to file for her mom and dad. Now, they did not have a lawyer, like I said. At this point, they file the alien relative petition. And hi, Tejas82, I see you on Instagram. Thank you for watching. And they file the green card application. Now, they could have filed a work permit for the work permit and a travel document, but they didn't know about it. And that's essentially for the Social Security number as well. Now, had they come to me in May of 2021 and said, here's the situation, what should we do? I would have advised them to wait 3 months from their entry. Why? Well, when you enter a number of reasons. First of all, when you enter on a B2 visitor visa or a B1, you're generally given 6 months to remain in the US. So you have 6 months where you're still in status. That's number one. Number two, it doesn't even matter if the parents overstayed. For the purposes of getting a green card, it would matter if they were going home to India and then trying to return to the US. If they overstayed, they're probably going to get denied upon entry. But in order to adjust their status in the US, they're considered immediate relatives. And of course, as I've said many times, immediate relatives, which include spouses of US citizens, parents of children over the age of 21 of US citizens, and minor unmarried children, so children under the age of 21 of US citizens, essentially, are immediate relatives. So you're basically excused for your overstay. So even if they went past the 6 months and then the daughter filed, if that was the ultimate plan, they wouldn't be penalized. Now, I just want to say one thing real clear, because people ask us this all the time, wanting to bring a family member here, should I have them enter on a visitor visa, or should I file for them while they're abroad? The correct answer is you file for them for when they're abroad. When you enter on a visitor visa, you get to the border. Well, first you go to the embassy to get your visa. You make a representation to immigration and say, I am going to visit, and then I'm going to come back. When you get to the border, you're making another representation to immigration and customs officials. when you go through customs and they say, well, what's the purpose of your visit? Well, I'm visiting, family. When are you returning home? I'm returning home blank. So you don't want them to think you lied at that point. It looks like on Instagram we have a question: can we apply for citizenship before 5-year rule, i.e. 90 days before? Well, we're not talking about citizenship today, but yes, that's a simple question. If you're eligible for citizenship after 5 years of being a permanent resident, then you technically, the first date you can file is 90 days or 3 months before that 5-year anniversary of your green card. So if you got your green card 5 years ago today, you could have filed, what are we in, April, March, February, January. You could have filed starting in January of 2023 if today was your 5th year anniversary of having a green card. I hope that answered your question. But if you have any questions, feel free to reach out to me on Facebook and YouTube. My contact information is scrolling across the bottom of my screen. Instagram, go to our bio page to find it. I'm happy to answer questions about this case right now. Any other questions, we will try to please contact me after this, because I definitely want to answer everyone's questions, but want to stick to this case. So, like I said, I would have told him to wait. We have this 90-day rule. If this rule has changed, you're very welcome, Tejas. This rule has changed back and forth depending on the president, but we're back to the 90-day rule. And what the 90-day rule says is it's a different 90-day rule than the citizenship rule. When you enter the U.S. as a visitor, if you do anything within the 90-day period that is contrary to your non-immigrant intent, then there's a presumption of fraud and misrepresentation. So what does that mean? That means within 90 days of entering as a visitor, you marry a U.S. citizen. You file a green card application. Technically, I guess, buying a house, there's no exact list, but there are certain actions that are very clear. Applying for immigration benefits and getting married are the easy ones, that if you do, they can presume that you lied at the border. And then the burden is going to be on you to show, look, I didn't lie. My plans changed. Now that happens. I've had this plenty of times before. Plans do change. People come over here, they plan to visit. Their situation changes, whether it's their fault or not, and they can't go home, but they have a path to the green card, and then they file here. And that's okay. It's not ideal, but it's okay. So if you do this all within 90 days, you might have a very big problem. Now, they called me, so they ended up filing, or the daughter filed for mom and dad within a month of their entry into the country. Again, anybody who's just tuning in, let's try to get my screen good here. Anyone who's just tuning in, that is a risky move to do. And had they had a lawyer, I'm sure not just me, but any other immigration lawyer would have said, wait a little bit. But they filed. And then about a year after they filed both the I-130 alien relative petition and the green card application, the first part, the I-130, was approved. So then they called me a couple months later because it seemed like the green card application was stalled. And that's when they started to get nervous because, people start to go online and read things. They see this 90-day entry rule. I know if you're watching, I'm very bothered by my off-put hair right here, but I had to make a note of that. All right. So they were very worried that immigration was going to think there's fraud. So they called me. We did a consult. I talked to them about it. And I said, okay, what's the truth here? What was your goal? And, the daughter, who's, remember, a grown adult with her own family and children, said, look, my parents were coming to visit me. They were going home. My dad got really sick, and he eventually did pass away before she called me. I didn't want to send my mom back there with him dying, and I didn't want to send her back there after he died because we don't have any other family there. So I decided, you know what, let's file for them. She's been a US citizen for years, but had never filed for her parents, which is something that's also telling, because if she had gotten her citizenship the month earlier and then her parents came and then the month later they filed, then USCIS may have looked at it differently. But she's been a US citizen for a long time now. So, and I believe, again, I'm not 100% sure, but I believe that her parents had visited her multiple times in the past and went home, which again is an important thing for when you're looking at present behavior. They do look at your past behavior, your past immigration history. So I asked her, okay, so your parents come here, there's only a month in between, does dad see a doctor? What happened? So dad did see a doctor. We have that proof. And I said, okay, when did that decision change? What made you change that decision? And we kind of went through all the different factors. And from what she had told me, it did sound like there was no fraud or misrepresentation. It did sound legitimate that her parents were planning to go home. Dad gets sick. They change the plans. We don't want to send mom back to no one. Let's keep her here. And I said, okay, that is not a problem. I mean, USCIS may bring up a problem, but you can certainly deal with it by explaining the situation. And so then I said, look, there's nothing to do right now. We could put together a haul, I guess I'm calling it an anti-fraud and misrepresentation package, having your mom write an affidavit, putting in the doctor's appointments, putting in the death certificate, all of that. But I don't think we should do that yet. And part of the reason you don't do that yet is because you wait for USCIS to say that there's fraud, because they might not think there's any fraud. It might just, even a situation like this where it seems like it might be obvious, it's not always that obvious. And then I told her, most likely what would happen is they would send a request for evidence or call mom in for an interview. And I would advise you bring me along to the interview. And at that point, if the issue comes up, your mom explains it. And we have the evidence with us to be prepared. And if they're not satisfied with that explanation, they can issue a request for evidence. They can put in anything else we have. And in an absolute worst case scenario, we have to do a fraud waiver. And that's an I-601 waiver. So then we started to talk about, well, would they even qualify for a fraud waiver? And fraud waivers have to be based on an extreme hardship to your U.S. citizen or permanent resident spouse or parent. And that's where we ran into a little problem with our backup plan. That although it was her mom, she's the U.S. citizen, and her mom was the immigrant, mom's waiver had to be based on mom's spouse or parent. And that, there is certain things where you can use a dead spouse as a qualifying relative for certain things, but not for a fraud waiver that I've ever heard. So we did not want to have to get to the fraud waiver. What the plan was going to be was we were going to convince them there was no fraud, because there really legitimately wasn't. So I said, let's not do anything yet. We don't need to start putting things in USCIS's head that isn't there. Let's see what they say. And in the meantime, they did not know that they could apply for a work permit. And they weren't interested in the travel document. And they didn't know that when you apply for your work permit, you can also check the box, get your social security number. So what I did was I helped them apply for the work permit and the social security number. And I entered my appearance as their attorney for the green card application and asked for an update. A few months later, USCIS sent out a request for evidence, or an RFE, asking for mom's medical exam. Now, mom had submitted the medical exam back in 2001 when she first filed for the green card. And, we used to always file the medical exams with the green card application, but then they would expire and people used to have to redo them all the time. And then they changed the rule and said, you don't have to submit it with the initial application, just wait. But at the same time, they then expanded the validity period from 1 year to 2 years, which would have covered mom in this instance, except for the fact, because 2 years would be May 2023, except for the fact that they then changed the edition of the form. And I know specifically there's at least one edition change for the COVID vaccines. So she had to go do a new medical exam. So they sent the request for evidence, and I said, this is great news because they're asking her to go this is all they're asking, is for her to do a medical exam, not to talk about the entry, not to do anything else. And normally what they do is if they need you to do a medical exam or a new medical exam, if they're going to call you in for an interview, they just tell you bring it to the interview, the new one, in a sealed envelope. If they're not calling you in for an interview, and this is not 100%, this is so far, this has been for every client that this has happened to, but it doesn't mean that it will always be this way or this will be for everybody. When they send the request for evidence for that medical exam, that means they're not calling you in for an interview. And if they're only asking for a medical exam, provided you pass your medical exam and you have your vaccines, then in all likelihood, you're going to get approved. So I said, this is excellent. Go send your mom, go get your medical exam, and then you can either bring it or mail me the medical exam. I can send it in with the cover letter, with the request for evidence, or you could just mail it in. It doesn't make a huge difference. For just sending in a medical exam, I don't even write much of a cover letter. So the client said, it's easier for me, just, she lives in the suburbs, works in the city, but she didn't want to take a chance of mailing it and getting lost. She's like, I'll just send it out. And this was back in October of last year. And that was when we still had the extension for COVID-19 on all the deadlines. So even though it said, I think it was due in January, it was actually due in March. So she sends it back in and we wait. And we're waiting and we're waiting. And she's like, she had mailed it. I told her, make sure you mail it in a way, whether it's a certified mail or tracking, with tracking so that we could see it. So she overnighted it. So she showed it was signed for and everything. She had proof of the mailing. And make sure you save the proof of mailing like right away, because if anyone's ever gone on and sent a package and then, or was receiving a package and went on and looked, whether it's USPS, UPS, FedEx, they usually have a warning like this will stay here for 30 days or something. Keep the record now. So keep the record now. It's very important to keep your mailing records to USCIS. So she basically sent back everything like a week or two later, the sealed medical exam, and you always send in a copy of the request for evidence. So I think it was less than a few weeks ago, she calls me, the daughter, and says, I've been checking the status of the case and it hasn't updated. It hasn't said that they received the request for evidence, but I have proof it was delivered. And it says they're actively reviewing the case. And then she checked and she didn't understand what was going on. So it's like, well, you could check with your congressperson. They have a USCIS liaison whose only role is to help constituents with USCIS. So she contacted that person, and they said that USCIS didn't receive the request for evidence. They didn't receive, the response to the request for evidence. They didn't receive the medical exam. And so when she had contacted me, it was like a few days after the extension period the deadline to reply expired. And that's pretty nerve-wracking because you're always worried about a denial. Now, yes, you can refile in this situation as an immediate relative, even though she would then have an overstay, it would have been okay, but it costs money, it's frustrating, it's stressful. So I said, okay, well, it looks like they didn't get it. We don't know for sure, but if that's now, if your congressperson's telling you this, that means they probably didn't get it. It's possible, very possible, it did get delivered and it just didn't make it to the file. We need to get a new one. Go tell your mom to get a new sealed medical exam. So they go to the doctor, and the doctor won't give them another copy. Now, you have to have an original signature. You can't have copies of the medical exams, but you don't have to undergo a new medical exam and get new vaccines. So I was like, go back to the doctor and ask them to fill out the forms again, sign it, put it in a sealed medical exam. So they did. And she overnighted me the package so that I could write a cover letter with her proof of mailing, explaining, the response for the request for evidence was received on time. Here's the proof of mailing. However, your records indicate you did not receive it, so please accept this as a timely submission or a timely response. So I get the mail from her the next day, and it was very strange because it had looked like it had been opened and then taped. The package, it was just one of those, overnight envelopes. I opened the package, and there's her sealed medical exam, except the top of the sealed medical exam was ripped. Not all the way, but ripped. And then I was like, now she has to go get another one. I said, I gave the client the option. I'm like, we could try mailing it, but it is opened. I mean, you would have had to rip the envelope more in order to get the paperwork out. But, when they say sealed medical exam, you want to send them a sealed medical exam. And the daughter understood she didn't want to take any chances, but she's like, look, I don't want to mail it this time. Fortunately, she doesn't work too far from where I live. So I was like, this family have been through a lot. I was like, look, let's meet halfway, Midtown, and you can hand it to me. So she goes, mom gets the exam, the new medical exam for her. She brings it into the city. She gives it to me. I put the cover letter on top, and I mail it off. And again, I mail it with proof of mailing. And then the client calls me and says, after I mailed out the package, we just got another request for evidence saying we need the medical exam. And it was dated like a couple of days before, you always get it a couple of days after it's dated. So it was dated a couple of days before I mailed it. And I was like, well, this is great news. That means they're not denying it, because we were rushing to get the medical exam so that they didn't deny the green card application. And I'm like, well, they're essentially giving her another chance to submit it, which is great. And she's like, well, we just submitted it. Do we need to respond to this one? Now, that's always the big question. If you've ever watched any of my other videos where I talk about requests for evidence, especially the ones I get where I've already actually submitted the documents, and I always say, you always respond. That is true. But in this instance, we technically had already sent our response back. So I said to her, I'm like, let's see what they do with this medical exam when they receive it, because they have received it now. I mean, we could have just responded really quickly, although the one I put on top is the older one, but I explained it. So that might be enough. If the case remains open, we can always send another medical exam if we have to. So then I checked, and it went from we didn't receive your response to we received your response. I was like, oh, hallelujah, they received the response. And a week later, this morning, I got the approval notice in the mail. First thing I did this morning was take a picture of it and send it to my client. And she was very excited, as was I. this whole saga for this family can finally come to an end. I know, especially when, immigration can be frustrating, hard, strenuous, stressful journey. But when you're dealing with a loved one dying in the middle of it and that kind of being attached to the whole process, it makes it that much harder. And it makes it that much harder even to move on with dealing with the loss of a loved one. So I'm hoping that this can bring this family, this very nice family, some closure. They can move on with their life. Mom will be eligible for citizenship in 5 years. And to answer the question we had earlier today again, she can actually apply in 4 years and 9 months from today for her citizenship. That's the first day they will accept her application. And other than that, I wish them the best. Hopefully they should be getting the green card within the mail within the next 2 weeks. Hopefully they will, and that, we don't have to worry about that. But it will be a 10-year green card. And to sum up, the main things you want to look at here is it does pay to have an attorney from the beginning, no matter what. You can look things up all day online, but it doesn't mean you're getting the right answers. In this case, this family did get a little lucky because they didn't create a huge problem for themselves, but they could potentially have. The second thing is, keep in mind that 90-day rule. You don't want to even have a presumption of fraud, misrepresentation. Not only is it going to be more expensive to deal with, but it's going to delay your case. And I do think it may have delayed this case a little bit. And finally, when you receive the request for evidence, keep your eye on it. Make sure that's you have your tracking. Make sure that they received it. And make sure you keep your eye on the case status. If she hadn't been keeping her eye on it, we might not have noticed they didn't get it, and we might not have gotten a second request for evidence. There are times they could have just denied it. So this case, I didn't mean to talk about it even for this long, but I think there's some really important points here that I wanted to point out. So hopefully for anyone who's in a similar situation, this will help them as well. And the last thing I wanted to say, if you do file for a loved one and that person passes away, you technically should withdraw it. You can send in the death certificate, and your attorney can write a letter, or you can, the petitioner can write a letter, or whoever has power of attorney can write a letter to withdraw it. If you don't withdraw it, it's just kind of going to die. That was wrong choice of words. USCIS eventually would have asked Dad for the medical exam too, and we would have either replied, he passed, or if they ignored it, then it would have been denied eventually. But if it's a good idea to withdraw it. Just immigration they have enough to do. Hopefully will speed up your own case by notifying them as well. So that is all today for notable approvals. Don't forget to like us and follow us on Facebook, YouTube, Instagram. Got a new camera angle working here, which I'm struggling with a bit. We'll fix up the kinks for the next time. If you thought this video was helpful or know someone who may find it helpful, please hit that share button. And we will see you next time, and have a great day.